This video examines the property rights shell game behind the Cowichan debate, showing how the current discussion misframes the real constitutional issue. 5 legal systems are currently colliding within Canada's land ownership framework. The public narrative, particularly in media coverage, often frames the issue as a simple conflict: Indigenous title versus private property rights. This framing suggests homeowners and Indigenous title are directly conflicting entities. This framing is incomplete because it simplifies the debate into 2 sides. Canada's legal system, in reality, contains multiple overlapping rights frameworks, making the issue more complex. The real issue is the collision of several legal systems that developed during different historical periods. These diverse systems are now interacting within one land framework, creating complexity. There are 5 legal systems colliding: common law property rights, Canadian Bill of Rights protections, Crown sovereignty doctrine, Section 35 Indigenous title rights, and possession-based doctrines. System 1 is common law, which includes property rights, due process, and protection from arbitrary state interference. These are traditional safeguards for individual ownership and justice. System 2 is the Canadian Bill of Rights from 1960. Section 1 recognizes the right to life, liberty, and security, the enjoyment of property, and the right not to be deprived of property except by due process of law. It is an important point that the Charter of Rights and Freedoms is not the only rights instrument in Canada. The Canadian Bill of Rights still applies to federal law, showing these frameworks are coexisting and vital. Supreme Court cases like R v. Drybones, 1970, and Otherson v. Canada, 2003, confirm the Canadian Bill of Rights' legal relevance and continued application to federal law, affirming its primacy and operative nature. System 3 is the Crown sovereignty doctrine. The Crown claims ultimate sovereignty over land, and historically, this doctrine structured Canada's entire land ownership system. System 4 is Section 35 Indigenous title. Section 35 of the Constitution Act recognizes and affirms existing Aboriginal and treaty rights. Court decisions have significantly expanded the interpretation of Indigenous title. System 5 includes possession-based rights, such as adverse possession or squatters' rights, and long-term possession doctrines. These systems can alter ownership based on occupation and time. The structural problem is that these 5 systems were never fully integrated. Courts and policymakers often treat them separately, which creates widespread legal uncertainty regarding property rights. The public debate focuses mainly on 2 systems, which is the property rights shell game. Meanwhile, 3 other rights frameworks are quietly ignored, resulting in a distorted legal picture. This matters because when legal frameworks collide without a clear hierarchy, property uncertainty spreads, citizens lose clarity about their rights, and courts become the battleground for these unresolved conflicts. Citizens can take action by educating others about the Canadian Bill of Rights and its protections. Furthermore, challenge the assumption that the Charter is the sole source of rights and demand legal clarity on property rights from the government. Continue the action plan by encouraging public discussion on constitutional land frameworks. Support legal research and awareness, and share educational materials widely.